ma'am, is that correct? Have you in fact arrived at a verdict?
Yes, Judge.
If you will hand it to the bailiff will bring the verdict to me for my review. The verdict is in proper form to be received by the court. At this time, I'm going to ask the clerk to publish the verdict. Thank you, Mr. Phillips.
In the Superior Court of Cobb County, State of Georgia versus Justin Ross Harris, defendant, case number 14-9-3124, verdict form. We, the jury, find as follows: count 1, malice murder. As to count 1, we find the defendant guilty this 14th day of November 2016. Killed only 4 persons. Count 2, felony murder. As to count 2, we find the defendant guilty this 14th day of November 2014. Killed only 4 persons. Count 3, felony murder. As to count 3, we find the defendant guilty this 14th day of November 2016. CN, 4 persons. Count 4, cruelty to children in the first degree. As to count 4, we find the defendant guilty this 14th day of November 2016. CN, 4 persons. Count 5, cruelty to children in the second degree. As to count 5, we find the defendant guilty this 14th day of November 2016. CN, 4 persons. Count 6, criminal intent to commit a felony, to wit, sexual exploitation of children. As to count 6, we find the defendant guilty this 14th day of November 2016. CN, 4 persons. Count 7, dissemination of harmful materials to minors. As to count 7, we find the defendant guilty this 14th day of November 2016. CN, 4 persons. Count 8, dissemination of harmful materials to minors. As to count 8, we find the defendant guilty this 14th day of November 2016. CN, 4 persons.
Counsel approach to review the verdict. Does the state have further of the jury?
No, Your Honor.
Does the defense?
We'll ask for the poll.
Certainly. Ladies and gentlemen, we've received your verdict and it's been published in open court. The next step in a trial is the poll of the jury. The poll of the jury is when you're called upon to confirm that the verdict that has been rendered by the jury is in fact your verdict. The way I'll do that is the clerk will call your names by initials shortly. When your initials are called, please stand and I will ask you 3 questions. I'll ask you if you heard the verdict as it was read in open court, and then you would answer whatever your answer may be. The next thing I would ask is if the, then I will ask you if the verdict that you heard is in fact the verdict that you had in your jury room. Then I'll ask you if in fact the verdict that you heard is the verdict of all the jurors in the jury room. And finally, I will ask you if the verdict is still your verdict. And then, as you know, you're under oath. To all of those 4 questions, you would answer truthfully as the case might be as to what your answer would be. And with that, I'll ask Mr. Phillips to go and begin to call the roll of the jurors.
J.G.
Please stand. Did you hear the verdict as it was read in open court?
Yes, I have.
Was that your verdict in the jury room?
Yes, it was.
Was it the verdict of your fellow jurors?
Yes, ma'am.
And is it still your verdict?
Yes, it is.
Thank you. Please be seated.
C.P.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was wrong one? Eventually we'll be there. Yes, sir. Did you hear the verdict as it was read in open court? Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict? Thank you. Be seated.
CP.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, it was.
Is it still your verdict?
Yes, ma'am.
Please be seated.
SM.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Thank you.
NH.
Did you hear the verdict as it was read in open court?
Yes, Your Honor.
Was that your verdict in the jury room?
Yes, it was.
Is it still your verdict?
Yes, ma'am.
And was it the verdict of your fellow jurors?
Yes, Your Honor.
Thank you so much.
PE.
Did you hear the verdict as it was read in open court?
Yes.
Was that the verdict of, was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Thank you. Be seated.
PO.
Did you hear the verdict as read in open court? Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors? And is it still your verdict?
Yes.
Thank you.
JJ.
Did you hear the verdict as it was?
Two JJ. This is a male.
Did you hear the verdict as it was read in open court? Was that your verdict in the jury room?
Yes.
Was it the verdict of your fellow jurors? Is it still your verdict?
JR.
Did you hear the verdict as it was read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, ma'am.
Is it still your verdict?
It is.
Thank you.
GG.
Did you hear the verdict as read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes, ma'am.
Is it still your verdict?
Yes, ma'am.
JJ.
Did you hear the verdict as read in open court?
Yes, I did.
Was it your verdict in the jury room?
Yes, it was.
Was it the verdict of your fellow jurors?
Yes, it was.
Is it still your verdict?
Yes, it is.
KN.
Did you hear the verdict as read in open court?
Yes, ma'am.
Was that your verdict in the jury room?
Yes, ma'am.
Was it the verdict of your fellow jurors?
Yes.
Is it still your verdict?
Yes.
Is that all of the jury? Anything further from the state?
No, Your Honor.
Anything further from the defense?
Not as far as the jury's concerned, Judge.
We'll take up issues in a moment. We're going to give the verdict to the clerk. Ladies and gentlemen, that concludes your service on this case. So, what are next steps? Well, I'll be discharging you shortly, but I'd like you to know about the next steps in the case. As you remember that I told you in the charge of the court, I explained to you that sentencing was not an issue in your jury deliberations. And that's because we have a bifurcated system of jury trials, and bi means two, as you know. So the first step is the determination of guilt or innocence. You can't even begin to contemplate or consider or evaluate appropriate punishment until you've determined if a person is guilty or not guilty. And that is a jury function. That's where people from the community are brought together to bring about their really common sense. The verdict of a jury is the sense, the common sense of the 12 jurors who come from all different walks of life, evaluating evidence, applying law to evidence, and letting that create a verdict. But you can't talk about punishment until a person has been found guilty. It doesn't make sense. In cases such as this, once a jury arrives at a verdict, and in this case a guilty verdict, then the responsibility of sentencing falls to the trial judge, and that's me. And what happens is called a sentencing hearing. And at a sentencing hearing, there can be evidence offered. And evidence would come to the court in one of two ways. basically two natures. One is in the nature of aggravation, and the other is in the nature of mitigation. Aggravating evidence is evidence that would take you to, say you had a median sentence, that all things being equal, this would be the normal sentence in a case. Aggravating evidence would be that which takes you to a stronger social response. Punishment is a social response to behavior that's against the law. And if there's evidence that's offered, and it can be evidence from the trial, maybe nothing more than, and often is, that there's no more evidence other than what's been heard at the trial. So that could be aggravating evidence. But it could also be something like prior criminal convictions, other things of that nature that the law allows the sentencing judge to take into account in arriving at the appropriate punishment. The other type of evidence is mitigating evidence, and that which, if we're at the meeting point, takes you to a less harsh sentence. Youth is often considered to be mitigating. There can be evidence in the trial that amounts to mitigating evidence. Lack of a criminal record can be mitigating evidence. There's a hearing to accomplish that, and each side, the state, can offer evidence in aggravation. The defense can offer evidence in mitigation. And then, just as you saw in the trial, there's argument. Each side can state what they think is an appropriate sentence within the range that the law sets out, and argue to the court persuasively what's the appropriate sentence. I mentioned a feature that's important to keep in mind. I don't have unfettered decision-making, just like you didn't. You had law you had to follow based on evidence to arrive at a verdict. I have law I have to follow based on evidence in sentencing to arrive at a sentence. So what is the law specifically that I'm talking about? Each offense has sentences that are set forth by statute. The law that I told you about, when I define malice murder, when I define felony murder, when I define the cruelties to children and the dissemination counts, they all have ranges or specific punishments that go with that offense. And then there's some other nuanced aspects of how sentencing occurs. But after I discharge you, then I'll have to determine when the sentencing will occur. And I'll certainly want to share that information with you. You're a part of the case. I'm discharging you, and you're going to go back into your free lives, which you have not had for quite some time. And, for the rest of us, too, we haven't had our free lives either. We've been here in a very accommodating community. What's been here for us from Cobb County trying this case has been, hospitality's been remarkable. The support and help to us to do our task has been remarkable, and I hope for you that you find that to be true as well. I believe you probably do. It's just been very remarkable, and everyone involved should be commended. But to go back into your civic life and your civilian life, and yet I'm sure you would like to have the information so you can have access to being able to see and hear what happens in the sentencing. And I will be sure to get that to you so you will know. Why am I saying that? I don't know yet when we're going to do it. I need to listen to both sides. That's the next step after I discharge you, is to listen to the lawyers and talk about next steps as to when we get to sentencing. What type of preparation do they need? What is their time frame? Sometimes you try cases and you immediately have a sentencing. Oftentimes you have to wait because there are witnesses that need to be summoned and brought into court. So there's still moving parts on my end, at their end as well. Before I discharge you, I'd like to say to you that you've seen, in my opinion, very good trial work. The lawyers have done an outstanding job in representing Mr. Harris and making sure that not only were his rights protected, and sometimes we get a little jaded about rights, but rights matter because they define us as a society. And if, heaven forbid, we ever find ourselves in a circumstance or our family in a circumstance We want to make sure we live in a society where those rights protected to us are there for us. It's an equalizer. It makes us all equal under the law. And that's one of the hallmarks of American society. And you've seen very good lawyering in that regard. You've also seen very good development of the facts and circumstances. The presentation was very good, and I see lawyers all the time. I am one. I'm pleased to be one. I'm very proud of the career choices I've made that have given me such an ability to see how our system works, how justice works in our country and in Georgia. And you've seen very high quality work, and I commend the lawyers for that. Having